The autumn air carried an unusual chill through the marble corridors of the Supreme Court building that October morning, as though the weather itself sensed the weight of what was about to unfold inside the ornate chamber, where the nation's highest judicial body convened to hear arguments that would shape American law for decades to come. The case on the docket concerned voting rights enforcement mechanisms under Section 2 of the Voting Rights Act, specifically whether private citizens and civil rights organizations retained the ability to bring lawsuits challenging discriminatory voting practices, or whether only the Department of Justice possessed such authority. The question might have seemed technical to casual observers, but advocates on both sides understood that the answer would determine whether communities facing voter suppression would have any practical recourse when state and local governments erected barriers to political participation. The courtroom filled well before the scheduled start time, with every seat in the public gallery occupied by activists who had traveled from across the country, legal scholars who recognized the historic significance of the moment, journalists assigned to cover what their editors anticipated would be a consequential hearing, and congressional staffers representing members who had staked their reputations on defending what remained of federal voting rights protections after years of judicial erosion. Representative Jasmine Crockett occupied a seat in the section reserved for parties with direct standing in the case, her presence drawing attention from those familiar with her previous confrontations with judicial power and her reputation for preparation that bordered on obsessive in its thoroughness. She had spent weeks working with a team of civil rights attorneys to craft an amicus brief that marshaled historical evidence, constitutional analysis, and empirical documentation of ongoing voter suppression in ways that made ignoring the facts virtually impossible for anyone engaging with the materials in good faith. Her role today was ostensibly limited to observing the proceedings as a representative of the organizations whose brief had been submitted to the court, but those who knew her work suspected she had not invested so much time and effort merely to watch from the sidelines if opportunities arose to clarify the factual record or challenge legal reasoning that obscured practical realities. The atmosphere in the chamber carried that particular tension that precedes moments when abstract legal doctrines collide with fundamental questions about democracy and power, when the 9 individuals seated behind the mahogany bench would make decisions affecting millions of citizens whose voices would never be heard in this room, but whose ability to participate in self-governance hung in the balance. The case had arrived at the Supreme Court through a circuitous path that illustrated the broader struggle over voting rights in contemporary America. Several states had implemented new election laws following the court's decision in Shelby County versus Holder, which had gutted the Voting Rights Act's pre-clearance requirements and effectively invited jurisdictions with histories of discrimination to adopt restrictive measures without federal oversight. Civil rights organizations had challenged these laws under Section 2 of the Voting Rights Act, which prohibits voting practices that discriminate on the basis of race, regardless of whether jurisdictions are subject to pre-clearance. Lower courts had allowed these private lawsuits to proceed, finding that Section 2 contained an implicit right of action for private plaintiffs even though the statutory text did not explicitly authorize such suits. The states being sued had appealed to the Supreme Court, arguing that only the Justice Department could bring enforcement actions under Section 2 and that allowing private lawsuits violated principles of federalism and separation of powers. The practical effect of accepting this argument would be to make voting rights enforcement almost entirely dependent on the political priorities of whichever administration controlled the Justice Department, effectively eliminating accountability when federal officials chose not to challenge discriminatory practices for political or ideological reasons. Chief Justice John Roberts had authored the majority opinion in Shelby County and had consistently voted to narrow the scope of federal voting rights protections throughout his tenure on the court, often writing opinions that acknowledged the ugly history of racial discrimination in voting, while insisting that such history no longer justified robust federal oversight in the present day. His jurisprudence reflected a particular vision of constitutional interpretation that emphasized federalism, state sovereignty, and judicial restraint, combined with an apparent conviction that contemporary America had moved beyond the racial dynamics that had necessitated aggressive federal intervention during the civil rights era. Critics argued that Roberts's vision ignored or minimized ongoing patterns of discriminatory voting practices that took new forms but served the same purposes as the literacy tests and poll taxes of earlier generations. His opinions often treated voting restrictions as neutral administrative decisions, while dismissing evidence of discriminatory intent or effect as insufficient to meet demanding legal standards that his own decisions had established. The oral arguments today would provide Roberts with an opportunity to shape the discussion in ways that could predetermine the outcome, using his position as Chief Justice to frame questions and manage the proceedings in service of his preferred conclusion. The arguments began with the petitioner's counsel, a senior attorney from a prominent conservative legal organization that had built its reputation challenging civil rights enforcement mechanisms across multiple domains. His opening statement emphasized that Congress knew how to create private rights of action when it wanted to do so, that the text of Section 2 contained no explicit authorization for private lawsuits, and that courts should not invent enforcement mechanisms that the legislature had not clearly provided. He argued that allowing private lawsuits created a patchwork of inconsistent enforcement that undermined democratic accountability and forced states to defend against numerous legal challenges that drained resources and interfered with legitimate election administration. His presentation hit notes carefully calibrated to appeal to the conservative majority's stated commitments to textualism, judicial restraint, and respect for state sovereignty. Several of the conservative justices nodded along as he spoke, occasionally interjecting questions that seemed designed to reinforce rather than test his arguments. The liberal justices pushed back with questions about whether eliminating private enforcement would leave vulnerable communities without effective protection, but their questions seemed more about creating a record for dissent than about genuinely probing weaknesses in the petitioner's position. Chief Justice Roberts waited until the respondent's counsel had begun her presentation before intervening with the kind of question that revealed his underlying assumptions and signaled where he intended to lead the discussion. His tone carried the measured authority that came from 17 years presiding over the nation's highest court, modulated to sound reasonable and searching rather than confrontational or predetermined. He asked whether the attorney seriously maintained that Congress had intended to authorize potentially thousands of private lawsuits challenging state election procedures when the statutory text contained no explicit language creating such a right of action. The framing presumed that private enforcement represented an anomaly requiring clear authorization rather than a standard mechanism for vindicating federal rights that courts had recognized across numerous statutory contexts. The respondent's counsel attempted to explain that private rights of action had been implied in civil rights statutes since the 1962 that Congress had legislated against this background understanding, and that eliminating private enforcement would effectively nullify Section 2 by making enforcement dependent on executive branch discretion. Roberts interrupted with follow-up questions about whether implied rights of action remained viable after more recent Supreme Court decisions, emphasizing textualist interpretation, whether Congress could fix the problem through new legislation if it disagreed with the court's ruling, and whether concerns about enforcement gaps should influence judicial interpretation of statutory text. The exchange continued in this vein for several minutes, with Roberts systematically constructing a record that would support a narrow interpretation of Section 2 that eliminated private enforcement while claiming to simply follow the statutory text and established interpretive principles. His questions grew more pointed as he pressed the respondent's counsel to identify specific textual language authorizing private suits, dismissed references to legislative history and context as insufficiently definitive, and suggested that policy concerns about enforcement gaps were questions for Congress rather than courts. The other conservative justices joined in with questions that reinforced Roberts's framework, creating a coordinated interrogation that left little room for the respondent's counsel to articulate alternative interpretive approaches or to highlight the practical consequences of the narrow reading being proposed. The liberal justices attempted to interrupt this momentum with questions highlighting the absurdity of a civil rights statute that could only be enforced when the president wanted it enforced, but their interventions seemed more defensive than effective, unable to shift the fundamental trajectory of the oral arguments. That was the moment when the Chief Justice made what would prove to be a critical miscalculation, perhaps emboldened by the apparent weakness of the respondent's presentation, or perhaps seeking to demonstrate the strength of his position through an expansive statement of principles. Roberts shifted his attention to the broader question of whether robust voting rights enforcement remained necessary in contemporary America. He suggested that the nation had made tremendous progress since the 1962, that the election of a black president and the dramatic increase in minority office holding at all levels of government demonstrated that the kind of systematic discrimination that had justified aggressive federal intervention no longer existed, and that continuing to treat states as though they were presumptively engaged in racial discrimination when they made ordinary administrative decisions about election procedures was itself a form of regional prejudice that the Constitution should not tolerate. His statement represented a distillation of the colorblind constitutionalism that had guided his voting rights jurisprudence for decades, the claim that America had transcended its racist past and that acknowledging ongoing racial discrimination in the present was itself a form of backwards-looking obsession that prevented the country from moving forward. The statement hung in the air for a moment as attorneys and observers processed what they had just heard. The Chief Justice of the United States, essentially declaring from the bench that voting rights enforcement had become obsolete because racial progress had rendered it unnecessary. Before anyone else could respond, before the respondents' counsel could formulate an answer that would not sound defensive or accusatory, the Chief Justice recognized that there was a request to address a point of factual context that had arisen during his statement. The procedure was highly unusual, as Chief Justices typically controlled the flow of oral arguments with minimal interference, but there were precedents for allowing amicus participants to clarify specific factual assertions when questioning revealed significant gaps or misunderstandings in the record. Jasmine Crockett rose from her seat with the same composed determination that had characterized her previous appearances before judicial and congressional bodies, where power sought to avoid accountability through procedural formality and rhetorical misdirection. She approached the lectern with steady steps that echoed in the suddenly silent chamber, placed her materials down with deliberate care, and looked directly at Chief Justice Roberts, with an expression that communicated both respect for the institution and absolute refusal to defer to authority, when that authority was being deployed to obscure rather than illuminate truth. "Chief Justice Roberts," she began, her voice clear and controlled in ways that commanded attention without aggression, "you have just stated that the progress America has made since the 1960s demonstrates that systematic discrimination in voting no longer exists, and that continued federal enforcement represents an outdated approach to problems that have been largely solved. I want to address that claim directly because it rests on premises that are contradicted by extensive evidence in the record before this court, and by documented patterns of voter suppression that have accelerated dramatically in the years since this court's decision in Shelby County eliminated pre-clearance requirements." She paused briefly to let that opening frame register, then continued with increasing specificity and force. "The suggestion that electing a black president proves that voting discrimination has ended is rather like suggesting that because some people escape poverty, poverty no longer exists as a structural problem requiring policy responses. Individual success stories, while important and worth celebrating, do not eliminate systemic barriers that continue to affect millions of citizens whose experiences differ from those exceptional cases that capture national attention." She reached down and lifted a document from her materials, holding it so that the justices could see the official seal marking it as a government report. The record contains a comprehensive study by the Government Accountability Office, examining voting changes implemented in states previously covered by Section 5 preclearance between 2013 and 2018, the 5 years immediately following the Shelby County decision. That study documents that these states closed 1,688 polling places, with closures concentrated overwhelmingly in minority neighborhoods. It documents that these states implemented strict voter identification requirements that studies show reduce minority turnout by 2 to 3 percentage points compared to white turnout. It documents that these states cut early voting periods, eliminated same-day registration, and purged voter rolls using methodologies that disproportionately removed minority voters who had not missed any elections, but whose names appeared on lists that were never adequately verified for accuracy. She set the document down and looked directly at Roberts. "Those are not historical patterns from the 1960s, Chief Justice Roberts. Those are contemporary practices implemented in the immediate aftermath of this court removing federal oversight," suggesting strongly that the oversight was preventing discrimination rather than that discrimination had ceased to exist. Chief Justice Roberts shifted slightly in his chair, his expression moving from patient attention to something more guarded. He interjected with a question clearly designed to regain control of the exchange and reframe the discussion on more favorable ground. He asked whether Crockett was suggesting that any voting change that had disparate effects should be treated as discriminatory, and whether states retained any authority to make administrative decisions about polling place locations, identification requirements, and voter registration procedures, without facing federal lawsuits alleging discrimination. The question employed the familiar technique of treating reasonable requests for evidence and justification as unreasonable demands for perfection, suggesting that any federal oversight necessarily precluded legitimate state authority, rather than simply requiring states to justify decisions with discriminatory effects through evidence of legitimate purposes and consideration of less restrictive alternatives. Jasmine had anticipated this exact rhetorical move because it represented standard operating procedure for judges seeking to dismiss civil rights claims without explicitly endorsing the discrimination those claims documented. Her response was immediate and devastating in its combination of logical precision and empirical grounding. No, Chief Justice Roberts, I am not suggesting that disparate impact alone establishes discrimination, although I would note that this court's precedents have long recognized that impact evidence can be highly probative of intent when combined with other factors. What I am suggesting is that when states implement voting changes that predictably and substantially burden minority voters, when those changes are adopted through processes that minimize public input and maximize partisan advantage, when those changes serve no legitimate purpose that could not be achieved through less restrictive means, and when those changes follow patterns that have been used historically in those same jurisdictions to suppress minority voting, then the combination of these factors provides overwhelming evidence of discriminatory purpose that satisfies even the demanding standards this court has established. She leaned forward slightly, her voice gaining intensity without losing its measured quality. The record in this case contains all of those elements. It is not a close call, and it is not a matter of judges second-guessing reasonable administrative decisions. It is a matter of documented discrimination that states are implementing because this court removed the accountability mechanisms that previously prevented such discrimination. She continued before Roberts could interrupt, building her argument with the kind of relentless factual specificity that made evasion difficult and denial implausible. Let me give you a specific example that illustrates what we are actually talking about when we discuss contemporary voting discrimination. In 2016, North Dakota implemented a voter identification law requiring residential street addresses on identification documents. That requirement sounds neutral until you understand that many Native Americans living on reservations use post office boxes rather than street addresses, because mail delivery to reservations is often through central facilities rather than individual homes. The state knew this when it passed the law. Legislative staffers documented it in internal memos. Advocates testified about it during hearings. And when Native American voters were turned away from polls in 2018 because their identification showed post office boxes rather than street addresses, exactly as predicted, state officials defended the law as a reasonable verification measure. That is not hypothetical discrimination from history books, Chief Justice Roberts. That is intentional disenfranchisement implemented through facially neutral rules designed to exclude specific populations while maintaining plausible deniability. Chief Justice Roberts's expression had tightened, and his voice when he responded carried an edge that suggested the exchange was not proceeding as he had anticipated. He asked whether Crockett had evidence that the North Dakota legislature specifically intended to disenfranchise Native American voters, or whether she was simply inferring discriminatory intent from the fact that the law had disparate effects. The question attempted to resurrect the demanding intent standard that civil rights advocates had long argued made proving discrimination nearly impossible, requiring direct evidence of racial animus rather than allowing inference from the combination of knowledge, disparate impact, and absence of legitimate justification. But Jasmine refused to accept the premise that intent could only be proven through explicit statements of discriminatory purpose, and her refusal was itself a form of constitutional argument about how courts should understand discrimination in an era when overt racism had become socially unacceptable, but structural barriers persisted. Chief Justice Roberts, she responded, the question you are asking reveals a fundamental misunderstanding of how discrimination operates in contemporary America. Officials rarely announce that they are adopting policies to suppress minority voting. They instead adopt facially neutral policies while knowing those policies will have discriminatory effects, and they defend those policies using pretextual justifications that collapse under scrutiny. The legal standard for proving intent cannot require evidence that virtually never exists, without rendering discrimination claims impossible to prove, and effectively licensing discrimination as long as it is implemented through coded, language and neutral-sounding rules. She gestured toward the materials on the lectern. The record in the North Dakota case shows that legislators were told repeatedly that the street address requirement would disenfranchise Native voters, that they proceeded with the requirement anyway without attempting to accommodate tribal identification formats, and that they rejected proposed amendments that would have allowed tribal identification documents to satisfy the law. When decision-makers are warned that a policy will have discriminatory effects, when they adopt that policy without justification and without considering alternatives that would avoid those effects, and when the effects materialize exactly as predicted, at what point does knowledge plus action equal intent? She paused to let that question resonate, then delivered the observation that would define the entire exchange and reverberate through legal and political discourse for months afterward. The standard you are proposing would make proving discrimination impossible unless officials are foolish enough to state their discriminatory motives explicitly. That standard does not protect civil rights, Chief Justice Roberts. It protects discrimination by allowing it to operate through coded mechanisms that everyone understands but no one has to acknowledge. The 15th Amendment was not a suggestion that discrimination should be subtle rather than overt. It was a command that citizens shall not be denied the right to vote based on race, and that command is violated whether the denial is accomplished through literacy tests that explicitly target black voters or through identification requirements that accomplish the same purpose while claiming to serve election integrity. The silence that followed was profound, the kind of quiet that emerges when foundational assumptions have been challenged so directly that the usual patterns of dialogue cannot simply resume without acknowledgement. Several justices shifted in their seats, with Justice Sotomayor nodding slightly while Justice Kagan appeared to be making extensive notes. The conservative justices looked uncomfortable, perhaps recognizing that Crockett had articulated criticisms of their jurisprudence that would be difficult to dismiss as partisan attacks or failure to understand legal doctrine. Chief Justice Roberts sat motionless for several seconds, his expression unreadable, but his silence itself a departure from his usual command of oral argument dynamics. When he finally spoke, his voice had lost some of its earlier certainty, taking on a more cautious tone that suggested he was proceeding more carefully than he had initially planned. He asked whether Crockett believed that Section 2 of the Voting Rights Act required states to maximize minority voter turnout, regardless of other legitimate interests in election administration. Framing the question in a way that suggested any accommodation of minority voting interests would necessarily compromise election integrity or administrative efficiency. But Jasmine immediately identified this as another false dichotomy, another attempt to suggest that protecting voting rights meant abandoning all other legitimate concerns rather than simply requiring that restrictions be justified by evidence and implemented in ways that minimized discriminatory impact. Her response dismantled that framing with the same combination of legal analysis and empirical grounding that had characterized her previous answers. Section 2 does not require states to maximize turnout, she said, her tone remaining respectful but firm. It requires states not to implement practices that deny or abridge the right to vote on the basis of race. That is a prohibition, not an affirmative mandate. States remain free to implement reasonable regulations that serve legitimate purposes, but they must actually demonstrate that those purposes are legitimate rather than pretextual, that the regulations are necessary rather than gratuitous, and that less discriminatory alternatives are inadequate. She continued with an example that illustrated the difference between legitimate regulation and discriminatory suppression. If a state wants to verify voter identity, that is a legitimate interest, even though there is virtually no evidence of in-person voter fraud that such verification would prevent. But the state cannot implement verification requirements that it knows will disproportionately burden minority voters, without considering alternatives that would achieve verification while minimizing that burden. North Dakota could have accepted tribal identification documents, could have allowed voters to use post office box addresses, could have provided free identification that met the street address requirement to affected voters. It chose not to pursue any of those alternatives, suggesting strongly that the real purpose was not verification but suppression. She looked directly at Roberts as she delivered her conclusion. The Voting Rights Act does not prohibit election administration. It prohibits discrimination in election administration. If states find that prohibition burdensome, the problem is not with the prohibition but with how they are choosing to administer elections. Chief Justice Roberts appeared to be formulating another question, but Justice Breyer interjected with an inquiry that built directly on Crockett's framework, asking about the specific alternatives that states had considered or rejected when implementing restrictive voting measures. This gave Jasmine the opportunity to walk through multiple examples from the record showing that states had consistently chosen the most restrictive options even when less burdensome alternatives were available and would have achieved the same stated purposes. She cited cases where states had rejected amendments to voter identification bills that would have accommodated voters lacking standard identification, where states had closed polling places in minority neighborhoods while opening new locations in white suburbs despite having adequate facilities in both areas, where states had implemented voter roll purges, using methodologies they knew were inaccurate, but proceeded anyway, because the errors disproportionately affected minority voters. Each example reinforced the central point that contemporary voting discrimination operated not through explicit racial classifications, but through facially neutral policies implemented with knowledge of discriminatory effects and without adequate justification or consideration of less harmful Alternatives. Justice Kagan followed with questions about how courts should evaluate state justifications for voting restrictions, particularly when states offered multiple rationales that seemed inconsistent or evolved over time. Crockett responded that shifting or inconsistent justifications should be treated as evidence of pretext, particularly when combined with evidence that the restrictions served no legitimate purpose or achieved no measurable benefit. She noted that states defending voting restrictions often claimed to be preventing fraud while producing no evidence that fraud existed at levels that would justify the burdens imposed, or claimed to be improving efficiency while providing no analysis showing that the challenged practices actually impeded efficient administration. Justice Kagan then asked whether courts should require states to conduct studies before implementing voting changes to assess whether those changes would have discriminatory effects, and Jasmine responded that, while formal studies might not always be necessary, decision-makers should be required to consider available evidence of likely effects and to explain why they proceeded despite evidence of discrimination. She emphasized that this requirement was not novel or burdensome, but simply reflected basic principles of reasoned decision-making that applied in other legal contexts and should apply with even greater force when fundamental rights were at stake. Justice Sotomayor took the opportunity to ask about the role of private enforcement in vindicating voting rights, bringing the discussion back to the central question before the court. She noted that the Justice Department had limited resources and political constraints that might prevent it from challenging every instance of discriminatory voting practices, and she asked whether eliminating private enforcement would leave gaps that would effectively nullify Section 2 in practice. Crockett responded emphatically that private enforcement was essential, precisely because federal officials might decline to bring cases for reasons having nothing to do with the legal merits, whether because of limited resources, political considerations, or ideological commitments. She pointed out that many of the most significant voting rights victories of the past 50 years had come through private lawsuits brought by civil rights organizations and affected communities rather than through Justice Department enforcement, suggesting that private litigation served as an essential check on both state discrimination and federal non-enforcement. She also noted that eliminating private enforcement would create perverse incentives, effectively rewarding states for implementing discriminatory practices during administrations unlikely to challenge those practices, and creating a political calculus where voting restrictions became tools of partisan advantage rather than subjects of legal accountability. Chief Justice Roberts interjected again, this time asking whether unlimited private enforcement might lead to excessive litigation that burdened states and interfered with legitimate election administration. His question attempted to resurrect concerns about litigation costs and federalism that had been central to his Shelby County opinion, suggesting that protecting states from lawsuits was itself a constitutional value that should limit federal voting rights enforcement. But Crockett immediately challenged that framing, noting that litigation was only burdensome when states implemented legally questionable practices, and that the remedy for excessive lawsuits was not to eliminate enforcement mechanisms, but for states to comply with federal law. She pointed out that states facing voting rights lawsuits could avoid litigation entirely by conducting pre-implementation reviews to assess discriminatory effects, by considering less restrictive alternatives, and by providing evidence-based justifications for any restrictions they chose to implement. The fact that states consistently failed to take these steps suggested that concerns about litigation burdens were pretextual, serving as cover for objections to accountability rather than reflecting genuine difficulties with compliance. She then delivered what legal observers would later identify as the most consequential moment of the entire oral argument, the statement that would be quoted in countless articles and academic papers, and that would fundamentally reframe debates about voting rights enforcement. Chief Justice Roberts, she said, her voice carrying both passion and precision, you have suggested that robust federal voting rights enforcement is no longer necessary because America has made progress on racial equality. But the premise of that argument is that civil rights protections should be withdrawn when things improve rather than maintained to ensure that improvements continue. That is not how we treat any other fundamental right. We do not eliminate free speech protections because the government has not recently censored unpopular views. We do not eliminate Fourth Amendment protections because unreasonable searches have declined. We do not eliminate due process protections because wrongful convictions have decreased. We maintain those protections precisely because they work, because removing them would invite the very abuses they prevent. The same principle applies to voting rights. The fact that federal enforcement has constrained discrimination does not prove that discrimination has disappeared. It proves that enforcement is effective and should be maintained. She paused, and the pause carried its own rhetorical weight, a moment of silence that allowed her next words to land with maximum impact. The question before this court is not whether America has made progress on voting rights. The question is whether this court will allow that progress to be rolled back by eliminating the enforcement mechanisms that made progress possible. The evidence shows unambiguously that when this court weakened federal oversight in Shelby County, states immediately implemented discriminatory practices that had been prevented by pre-clearance. If this court now eliminates private enforcement, states will have even greater freedom to suppress minority voting, because the Justice Department cannot and will not challenge every discriminatory practice. She looked directly at Roberts, her gaze steady and unflinching. "You have the power to make that choice, Chief Justice Roberts, but you do not have the power to avoid responsibility for its consequences. If minority voting is suppressed after this court eliminates private enforcement, that suppression will be a direct result of this court's decision, and history will judge this court accordingly." The courtroom erupted not with sound but with visible reaction. Journalists leaning forward, spectators exchanging glances, even some of the justices appearing taken aback by the directness of Crockett's statement. She had done something extraordinary, speaking to the Chief Justice, not just as an advocate making legal arguments, but as a citizen demanding accountability from public officials whose decisions would affect millions of people with no voice in this chamber. She had refused to treat judicial power as insulated from moral responsibility, had rejected the fiction that legal interpretation was a purely technical exercise divorced from values and consequences. Chief Justice Roberts sat motionless, his face revealing nothing, but his silence spoke volumes to those accustomed to his usual command of oral argument dynamics. He did not ask another question for the remainder of Crockett's time, instead allowing other justices to continue the questioning while he appeared to process what had just occurred. The conservative justices who followed with questions seemed more cautious than they had been earlier, perhaps recognizing that Crockett had laid bare tensions in their jurisprudence that would be difficult to resolve in a written opinion that would face public scrutiny. Justice Alito attempted to suggest that concerns about discriminatory voting practices were exaggerated by partisan advocates, but Crockett responded with specific examples and data that made dismissal impossible without openly embracing views that most Americans would find abhorrent. Justice Gorsuch asked about the text of Section 2 and whether it clearly authorized private enforcement, but Crockett walked through the statutory language and structure in ways that demonstrated implied authorization was consistent with text and necessary for effective implementation. Justice Kavanaugh asked about alternatives to private litigation, but Crockett explained why administrative enforcement was inadequate and why eliminating judicial remedies would effectively nullify statutory rights. Each exchange reinforced that the conservative justices' preferred outcome rested not on neutral legal principles but on contested choices about how to interpret ambiguous text, how much weight to give practical consequences, and whose interests deserved protection when competing values could not all be fully vindicated. When the oral arguments finally concluded and the court adjourned, the reaction was immediate and intense across every platform where legal and political developments were discussed and debated. Major news outlets led with headlines emphasizing Crockett's challenge to Roberts and her warning about historical judgment. Legal commentators across the ideological spectrum acknowledged that something unusual had occurred, with even conservative scholars admitting that Crockett had raised questions about the conservative voting rights jurisprudence that deserved more careful engagement than they typically received. Progressive activists and civil rights organizations celebrated the exchange as a rare moment of accountability, when someone with standing and expertise directly confronted judicial power with facts and moral arguments that could not easily be dismissed or ignored. Social media erupted with clips of the most dramatic moments, particularly Crockett's statement about historical judgment, which was viewed millions of times and sparked intense discussions about the Supreme Court's role in American democracy and whether lifetime appointments allow justices to avoid accountability for decisions with profound consequences for vulnerable communities. The academic response unfolded more slowly but with equal intensity as law professors integrated the oral argument transcript into their courses and published articles analyzing both the legal substance and the broader implications of Crockett's intervention. Several prominent constitutional law scholars noted that she had effectively deployed originalist arguments about the 15th Amendment's purpose and the Reconstruction Congress's understanding of federal enforcement authority, complicating conservative claims that originalism required narrow interpretations of voting rights protections. Others focused on her use of empirical evidence to demonstrate that recent voting restrictions followed patterns of historical discrimination and served no legitimate purposes that would justify their discriminatory effects, showing that progressive legal arguments could meet conservative demands for factual rigor while still supporting robust civil rights enforcement. Still others examined the confrontation as revealing fundamental tensions in American constitutionalism, between judicial supremacy and democratic accountability, between legal formalism and attention to real-world consequences, between claims of neutral interpretation and the reality that all interpretation involves contested value choices. Behind the scenes, according to sources familiar with the court's internal deliberations, the justices engaged in unusually contentious discussions during their private conferences in the weeks following oral arguments. These accounts, reported by multiple journalists with reliable court sources but never officially confirmed, suggested that Chief Justice Roberts had been particularly affected by the exchange with Crockett, not because it had changed his fundamental views, but because it had exposed those views to criticism that would be amplified in any opinion he might write. Some sources reported that Roberts had circulated a draft opinion eliminating private enforcement under Section 2, but had struggled to respond persuasively to the arguments Crockett had raised about the consequences of that decision and the evidence of ongoing discrimination that made private enforcement necessary. Other justices had apparently pushed back on some of Roberts's reasoning, noting that the factual record was stronger than his draft acknowledged, and that eliminating all private enforcement represented a more dramatic departure from established practice than narrow holdings focused on specific procedural requirements might accomplish. The decision, when it finally emerged several months later, reflected these internal tensions in ways that surprised observers across the political spectrum. The court issued a fractured ruling that preserved private enforcement under Section 2 but imposed new procedural requirements that made such lawsuits more difficult to bring and more demanding to prove. Chief Justice Roberts wrote the lead opinion, joined by Justices Kavanaugh and Barrett, finding that Section 2 contained an implied right of action for private plaintiffs, but establishing heightened pleading standards and requiring plaintiffs to demonstrate not just discriminatory effects, but also evidence of discriminatory intent beyond what previous decisions had required. The opinion attempted to strike a middle ground that acknowledged ongoing discrimination while making remedies more difficult to obtain, and legal scholars immediately noted that the opinion contained language responding to arguments Crockett had raised, even though it did not cite her intervention directly. Roberts emphasized that the court was not eliminating private enforcement entirely, suggesting that concerns about leaving vulnerable communities without recourse were overstated, but critics pointed out that the new requirements would effectively bar many meritorious claims, and that the distinction between narrowing and eliminating enforcement was more rhetorical than substantive. Justice Thomas wrote a concurring opinion, arguing that the court should have eliminated private enforcement entirely, and suggesting that the majority had been unduly influenced by policy concerns rather than focusing on statutory text. Justice Alito joined Thomas's opinion and wrote separately to dispute the empirical evidence of ongoing discrimination, claiming that voting restrictions were politically motivated rather than racially discriminatory, and that courts should not second-guess state legislative decisions. The conservative concurrences made clear that at least 2 justices remained committed to the most restrictive possible interpretation of voting rights, and that the narrow majority opinion represented compromise rather than genuine engagement with the evidence and arguments that Crockett and others had presented. Justice Sotomayor wrote a dissent, joined by Justices Kagan and Jackson, that cited Crockett's oral argument extensively and praised her intervention as having illuminated the real-world consequences of weakening voting rights enforcement. The dissent walked through the evidence of post-Shelby County discrimination that Crockett had highlighted, the examples of contemporary voter suppression that she had detailed, and the logical flaws in treating color blindness as a constitutional requirement when racial inequality persisted in measurable and documented ways. The dissent also addressed directly the question of historical judgment that Crockett had raised, noting that the court had been on the wrong side of history during Reconstruction when it narrowly interpreted the 14th and 15th Amendments in ways that enabled Jim Crow, during the early 20th century when it upheld literacy tests and grandfather clauses, and during the 1952 when it resisted Brown v. Board of Education's implementation. The dissent argued that the majority was repeating these mistakes by prioritizing abstract principles of federalism and textualism over concrete realities of discrimination, and by treating formal equality as sufficient when substantive inequality persisted. Justice Sotomayor concluded with language that echoed Crockett's warning, stating that history would not judge kindly a court that weakened voting rights protections at precisely the moment when those protections were most needed to counter resurgent efforts at voter suppression. The dissent's citation of Crockett's arguments ensured that her intervention would remain part of the permanent record, available to future advocates and future courts that might be more receptive to her reasoning and more willing to prioritize voting rights over competing considerations. In the immediate aftermath of the decision, Jasmine Crockett held a press conference where she acknowledged that the outcome was mixed but emphasized that the court had declined to eliminate private enforcement entirely, which she attributed in part to the effectiveness of advocates in demonstrating why such enforcement remained necessary. She noted that the new procedural requirements would create challenges but insisted that civil rights organizations would adapt their litigation strategies to meet those requirements, while continuing to press for legislative solutions that would restore robust federal voting rights protections. She also announced that she would be introducing legislation to strengthen Section 2 by explicitly authorizing private enforcement and establishing clear standards for proving discrimination that would override the court's narrowing interpretations. The legislation had little chance of passage given political dynamics in Congress, but it served to keep voting rights issues in public discourse and to provide a vehicle for mobilizing constituencies who understood that protecting democracy required ongoing vigilance and organization. The longer-term significance of the confrontation between Crockett and Roberts extended well beyond the immediate legal outcome. The exchange had demonstrated that Supreme Court justices could be challenged directly and effectively when they made claims unsupported by evidence or when they constructed legal frameworks designed to reach predetermined conclusions, while maintaining the appearance of neutral interpretation. Crockett had shown that speaking truth to judicial power remained possible and potentially impactful even in an era of conservative judicial dominance, and that advocates who combined technical legal expertise with moral clarity and empirical grounding could force justices to confront uncomfortable questions they might prefer to avoid. Her intervention had also illustrated the importance of representation and diverse perspectives in legal proceedings, as her background and experiences informed her understanding of how voting restrictions actually functioned in ways that complemented formal legal training and allowed her to identify practical consequences that others might overlook or minimize. The confrontation inspired renewed discussions about Supreme Court reform among progressives, frustrated by the conservative majority's systematic rollback of civil rights protections and other precedents. Proposals for term limits, court expansion, jurisdiction stripping, and democratic accountability mechanisms gained traction as people recognized that lifetime appointments allowed justices to ignore evidence and public opinion without facing consequences. Crockett became a prominent voice in these debates, testifying before Congress about structural reforms that would make the judiciary more responsive to democratic values while preserving judicial independence in ways that protected rather than undermined fundamental rights. She argued that the current system allowed justices to exercise enormous power without meaningful accountability, creating incentives for ideological decision-making and allowing personal and political preferences to masquerade as neutral legal interpretation. Her arguments drew on her experience challenging Roberts, using that confrontation as evidence that justices would resist accountability when possible, and that structural reforms were necessary to ensure judicial decisions reflected reasoned analysis rather than predetermined outcomes. Educational institutions and advocacy organizations used the oral argument exchange as a teaching tool, showing students and activists how to prepare for confrontations with power, how to ground arguments in evidence that could not easily be dismissed, and how to speak with conviction while maintaining credibility. Law schools assigned the transcript as required reading in courses on constitutional litigation, civil rights, and professional responsibility, using it to illustrate both substantive debates about voting rights and strategic questions about effective advocacy. Civil rights organizations incorporated Crockett's approach into their training programs, emphasizing the importance of factual preparation, logical rigor, and moral clarity when challenging institutional power. Youth organizing groups used clips from the oral argument to demonstrate that political engagement could produce concrete results, and that speaking truth to power remained possible even when power seemed insurmountable. Years later, when historians assessed the voting rights jurisprudence of this era, many would point to the Crockett-Roberts exchange as a moment when the conservative legal project's internal contradictions were exposed with unusual clarity. Roberts had spent his career claiming to simply apply neutral legal principles while consistently reaching outcomes that benefited Republican political interests and disadvantaged minority voters. Crockett had systematically dismantled that claim by showing that his principles rested on contestable assumptions, ignored inconvenient evidence, and produced consequences that he seemed unwilling to defend when stated explicitly. While the immediate legal outcome had been disappointing for voting rights advocates, the exchange had planted seeds that would grow into more sophisticated challenges to conservative jurisprudence and into political movements demanding structural reforms that would make courts more accountable. The confrontation had also demonstrated something crucial about democratic citizenship, that accepting elite interpretations of law and constitution was always a choice rather than a necessity, and that ordinary people working together could challenge even the most powerful institutions when they armed themselves with facts, logic, and moral conviction. If watching Jasmine Crockett systematically challenge Chief Justice Roberts' assumptions about voting rights and historical progress made you think about how legal decisions shape who gets to participate in democracy and who gets excluded, make sure you subscribe to this channel and turn on notifications, because these battles over the meaning of equality and the scope of federal power to protect fundamental rights continue every day in courts and legislatures across America, and we will keep covering every development that determines whether this nation finally fulfills its promise of government by the people, for the people, and of the people, with no one left out based on race or any other characteristic that should be irrelevant to citizenship and political participation.